Hello, everyone. My name is Marcio Kotz. I'm the Chief Operating Officer for Get Global International. So, welcome, everyone. For those who don't know Get Global International, we are we are a little bit more than data privacy. We are a digital governance consulting firm. We've been working with data privacy for more than 10 years already. And recently, we've been working quite a lot with AI governance. So this is our AI data privacy compliance for global markets. It's a two-part event. So we are going to have the first section today, and the next one will take place next week. Today, we're going to talk about data privacy across the globe, focusing on software companies. And next week, we're going to talk about AI governance. So today, as I said before, we're going to talk about data privacy and compliance, global challenges for software companies. Most of our clients, especially here in the United States, are in the software business. And one of the things that American companies need to deal with is the fact that their products need to be compliant with data privacy regulation across the globe. And that's pretty much what Get Global International is. Get Global International is as I said, digital governance consulting firm with more than 10 years in the market. And we help companies doing business in various locations across the globe in getting compliant with local regulation. And what I mean by local regulations are the regulations related with data privacy and AI. We are not a law firm. That's something that it's really important to inform you, because the idea, Get Global's idea, is to go way beyond the legal stuff. Of course, we do work with data privacy and AI governance lawyers. I am a European and Brazilian tech lawyer myself, but Get Global International goes way beyond that. We don't only draft privacy policies or privacy notice and things like that, especially here in the United States, because usually companies are sued mostly not only because of the company's negligence in not complying with the data privacy regulation, but mostly because they don't fulfill their promises or the promises they make in their data privacy policies or data privacy notices. So on the other hand, those documents are legal documents, and if you don't fulfill the promises that you make, you might get into some legal matters. I've been working with data privacy, as I said before, for more than a decade. I got my green card based on extraordinary abilities, mostly because of my career helping European governments and European companies to develop and implement digital governance compliance programs. And I also had the pleasure to work with the Brazilian government drafting the Brazilian LGPD. So let's talk a little bit about how American companies need to deal with data privacy in the United States. So nowadays there are the American standard follows two different. It has two different approaches. One is the sectorial approach based on the industries that are regulated, and it has been like that until California decided to pass its own data protection regulation. So now we have these two standards. So we have some sectorial regulations and some state regulations. And that's pretty much how it works in the United States. Here is just a short, it's a chart that shows us, which states has already passed data protection regulations. So even domestically, American software companies, they need to deal with a large number of data protections regulation in the country, because more than 15 states have already passed a data privacy regulation. And try to imagine the challenge of for a software company to make sure that the company's product is compliant with every one of those regulations. And once again, it's not a question of drafting privacy policies for each one of those states. We need to make sure that the software is handling personal information compliant with the regulation and aligned with the privacy policies. So as I said before, it goes way beyond just working on the documentation. But would it be enough for US companies to get compliant with US data privacy regulation? I would say that the challenge go way beyond that, because most of those software companies, they want to sell their product internationally. So on the other hand, there are some other things that we need to consider, especially if we want to sell to regulated regions like Europe or Australia. India has just passed its own data protection regulation, Argentina, Colombia, Brazil, and so on. So the fact is that in the US, there isn't a comprehensive federal privacy law. So US privacy regulation is fragmented and sector specific. So that's one of the challenges. There is no unified national law governing the general processing of personal information, unlike the European GDPR, for example. As a result, companies must navigate a patchwork of state laws and industry specific rules. Besides that, there is another big challenge to be addressed, which is the international data transfer. Every time that we transfer personal information from one location to another location internationally, we need to analyze if that would be considered, how that should be treated by data protection international laws, because there is a very fragile, I would say, agreement between the United States and Europe that regulates these international data transfers. And why do we need such agreement? Mostly because the US follows a different data privacy regulation standard compared with Europe, for example. So on that matter, there have been some previous agreement between the US and Europe that has been invalidated by the Court of Justice of the European Union. Nowadays, there is an agreement between the US and Europe, but I would say that at certain point, that agreement could definitely also be questioned in court. But that's pretty much what we have to work with. And one of the requirements is that American companies that do international data transfer, they need to get a self-certification. And that self-certification, at the end of the day, is pretty much having US companies making a lot of different promises, a lot of different commitments with the US and the European government on the way the company will make those international data transferred. So if the company doesn't comply with all the statements that the company makes to the governments, they might also have some sort of legal issues to deal with. So that's another thing that we need to deal with when it comes to software companies, American software companies doing business abroad, because we do know that most of the softwares, they need to collect personal information. So on the other hand, there will probably be international data transferred. It's important to notice that outside the US, US software companies, they sell a lot to the international market. Here's this a survey by one consulting firm, and it shows that US digital exports in 2021 represented of more than $40 billion to Europe, more or up to $30 billion to Asia, and about $15 billion to the Americas. So it shows that US software companies make a lot of money outside the United States. So all those data privacy challenges need to be addressed by those companies. Otherwise, there will be some consequences. So the challenges for software companies are pretty much these ones. A jurisdictional complexity. Each region has distinct requirements around consent, data retention, transfer, and user rights. Standardizing compliance may lead to local violation or rework. So it means that we need to address every regulation. We need to make sure that the software complies and handles personal information properly, compliant with every regulation. The second challenge is cloud-based apps often process and store international users' personal information. So that means that probably we'll have to deal with international data transferred. The other challenge is the fact that if your software, if the product is not compliant with the local regulation, at the end of the day, there will be loss of market share. Because the local companies, your potential clients, will probably make a lot of questions, data privacy questions, on how the product handles personal information. Things like what kind of personal information is collected in order for me to use the software. Why does the software need to collect that specific personal information? Would that personal information be necessary for that specific purpose? Where do you store the personal information? Will there be any sort of international data transfer? Or there are so many different things that we need to understand before we buy a software. So a European company, a Latin American company, or a company from Singapore, from India, they definitely need to understand what kind of software they are buying. Just to give you a piece of information, Bain Company, a very prestigious consulting firm, and also Gartner, they both conduct different surveys on the B2B software buyer behavior. And one of the questions was, for what reason wouldn't you buy a B2B software? And on the second place, right after UX, is data privacy concerns. So loss of market share is pretty much the outcome of that could arise if the company doesn't deal with data privacy and doesn't take the actions necessary to make sure from scratch that the software is using personal information properly. So definitely we should apply, many different methodologies in order to make sure that the product would be compliant. So every time that a potential client makes those questions to understand if the software would be compliant with the regulation, we would have the possibility to answer those questions and even prove that the software is compliant with the local regulation. And that leads us to the next challenge, lack of understanding. The fact is that many American software companies, they just don't understand how those regulations work. So we've seen a lot of comments. We have heard a lot of different comments from professionals who believe they understand the way they should deal with data privacy abroad, but things that just are very superficial. For example, if I'm compliant with the US regulation, I don't need to be compliant with international regulation. That's a big mistake, because your client, the company that will buy your software, they will have to comply with the local regulation. So if they buy your software and your software that they will be using is not handling personal information compliant with their regulation, they won't buy your software. Or things like, it's a legal matter, so I will, engage, I will hire a lawyer to draft the data privacy agreement or the privacy policy. That's another mistake, because that's just documentation. If the software doesn't handle personal information aligned with all the promises you are going to make on the document, that will not happen, and that will not help. So there is a lack of understanding, how things should be done in order to make this software compliant with local regulation. So let's talk a little bit about situations involving this lack of understanding, because I believe that everything starts with information. So as I said before, if you don't comply with your own document, with your own privacy policy, with your own privacy notice, with your own data privacy agreement, um, there could be some sort of a breach of contract. Promises like, we'll keep your data secure, are contractual obligation. Breaking those promises can lead to lawsuits from customers. Or it could also be considered breach of warranty. Statements like, our product is secure, are explicit or implied warranties. If they are false, the company can be held legally liable. So contract-based claims are often stronger than negligence claim. Courts take a written agreement seriously, especially early in litigation. So let's then understand how the GDPR, for example, the European General Data Protection Regulation work, because the GDPR is a sort of a global standard. Many other locations, they pretty much follow the European standard. So places like India, for example, it follows pretty much the European standard. Of course, there are some things that are different. So one of them, for example, in Europe, there are 6 different situations called lawful bases or legal bases that you can handle personal information. And if you don't follow under at least one of them, you are not compliant with the regulation. So there are 6 different possibilities that you could handle personal information. And under the Indian, the data protection regulation in India, there isn't one of the legal bases called legitimate interest. Just to give you an example, that there are things that are different. Or if you compare the European General Data Protection Regulations with its 6 different legal bases with the Brazilian LGPD, the Brazilian Data Protection Regulation has 10 different legal bases, 10 different situations that you could use to handle personal information. So there are things that are a little bit different, but at the end of the day, they follow pretty much the same standard. So part of this standard is the fact that we always need to identify if we have a specific legal base under the regulation to handle personal information. The second thing that we need to worry about is the principles. Principles are boundaries on how the software can handle personal information. So one of them is data minimization. We cannot collect as much information we want. We only can collect the information necessary for that specific purpose. So at the end of the day, it's just an example of a data privacy principle, but it shows that it sets some boundaries on how the software can handle personal information. Another thing that we need to deal with, besides identifying the legal base, being sure that the software is handling personal information aligned or compliant with the principles, we need to be ready to comply with the data subject rights. So every individual under those regulations, they have different rights. One of them is the right to access, to have access to the personal information that the company is handling. So if the software doesn't help the client to identify what personal information the software is handling, that will be something that the buyer will consider before buying your software. So, and of course, at the end of the day, the data, the personal information needs to be protected. It doesn't make sense if the software is handling personal information compliant with the regulation, if there is some sort of data privacy incident, some sort of a data leak or things like that. So that's pretty much the standard itself. And that standard is quite different than the American standard. There isn't such thing as legal base or situations under the law that I can handle personal information, that I need to identify what legal base would allow me to handle personal information under the American regulation. So that's a general data protection regulation. This European global standard has been followed by many different countries, various countries around the globe. So here are some of the obligations for US companies, even though they are not based in those places, even though you don't have some sort of legal representation in those places. But just by selling your software to those places, you need to comply with those obligations. One of them is you need to appoint a European Union representative if no physical presence, if you don't have any physical presence in Europe. You gotta use updated standard contractual clauses for international data transfer. That's how usually we deal with international data transfer, besides getting the self-certification that I previously talked about. You also got to implement some technical and organizational safeguards, things like encryption, for example, access control. So there are some technical and organizational safeguards that you need to implement. And that's pretty much what Get Global International does. We help you to identify the data gaps, make the changes in the software, front end and back end, in order to make sure that you implement those technical and organizational safeguards. Besides that, we also help you with the international data transfer, and we also can represent your company in those places as your DPO, your data protection officer. You also need to maintain records of processing activities under the European GDPR and ensure data subjects' rights are respected. So at the end of the day, there are so many different things that we need to deal with, and it changes from time to time. So keeping track of those changes is something that is time consuming. So maybe looking for some consulting firms that can help you with that would definitely bring some sort of I would say a better environment in order to make sure that the software is compliant with the local regulation. Here's just one example of the many changes that has already happened just related with international data transfer. So all those changes in many different matters, in many different data privacy topics, it's hard to keep track if you are not some sort of data privacy professional. So that's also a big challenge for software companies. Here are some examples of I would say middle-sized companies that has happened some sort of data privacy issue to deal with. We didn't want to bring to you all those well-known cases that involved big tech companies in the United States, because we wanted to show you that even smaller companies, they can also need to deal with data privacy matters. So we have cases in Netherlands, in Portugal, and in Denmark that involved middle-sized software companies that didn't do the things that they should in order to make sure that their product would be compliant with the local regulation. So if you don't want to lose market share, you should definitely, consider developing and implementing a data privacy compliance program, aiming to make sure that the products are handling personal information compliant with, local data privacy regulations. Okay, if we compare the European GDPR in Latin America, so let's say that you sell your software to countries located in Latin America, just to give you some examples of Latin American countries aligned with the European standard. Brazil, which is definitely the biggest market in Latin America. And what I mean by the biggest is the size of the market. And it is the biggest Latin American economy by far. Even Chile, Mexico, Colombia, Uruguay, and Peru have some sort of data protection regulation aligned with the European standards. So that would also be a challenge if you sell to those countries. So common elements across the region are the legal basis, as I mentioned before. So we need to analyze if the software has some sort of a legal base to handle personal information. Also, the data subject rights. All those regulations also have the data breach notification. Also, the creation of independent data protection authorities. Every country in Latin America that has data protection regulation has its own data protection authority, and they increase the demand for compliance documentation and data privacy impact assessment. So if you are selling to those countries, your clients will probably will probably want from you some sort of a proof or evidence that your software is also compliant with local regulations. So on that matter, would it be possible to have a global privacy compliance strategies? I would say that it is possible. Get Global's name is inspired actually by its slogan. Get Global International slogan is digital governance, data privacy nowadays is global, because it is. So on that matter, the recommendations for software companies selling internationally is to adopt global privacy frameworks. And there are some of them. One of them is the NIST privacy framework, but there is also, in this slide before, there is also the ISO 27701. None of those frameworks will solve the whole problem, because the NIST privacy framework is based on the American regulation, and the ISO is pretty much based on the European regulation. And here we need to have an international approach. But we definitely need to go through some sort of methodology that I'm going to show you later, how it should be, how it should work, and all the steps we should follow in order to make all the changes in the way that the software handles personal information before we start working on the documentation. But besides adopting a global privacy framework, we need to create global policies at the end with localized adjustments by country or region. So at the end of the project, we should have a global data privacy policy, but with local privacy policies and privacy notices that would have some sort of adjustments to comply with local regulations. Another thing, in many different countries, the company will need to appoint DPOs, data privacy officers, or local representatives, because it's a legal requirement. So all those data privacy regulations aligned with the European standard, they come with these kind of obligation. So that's why Get Global International acts as many US companies' data privacy officers in different locations, because that's a legal obligation. Also deploy consent management platforms for user transparency and tracking. So sometimes we will have to implement some data privacy software solutions and embed those solutions in your software in order to make sure that the software is able to bring some sort of a transparency and keep track on the way the software is handling personal information. There is a set of different software solutions called PETS, and PETS stands for Privacy Enhancement Technology. So those solutions could help your software to bring that kind of a transparency and keep track on the way the software handles personal information. So sometimes we might advise you to embed those enhancement technologies to solve some of the gaps that we might identify. And of course, this is a teamwork. So another recommendation is start building some sort of a data privacy culture in your organization. Because if you are going to develop a new software, you need to apply privacy by design from scratch. So your legal team should have some sort of some knowledge on data privacy regulation. Your product manager needs to understand what kind of things they should consider regarding data privacy throughout the software development life cycle. Cybersecurity, they got to understand what personal information is and the kind of protection they should be working on in order to protect personal information. Engineering, software developers, everyone needs to be trained on how to deal with data privacy internationally if the company is selling software internationally. But the main point here is to adopt a global privacy framework, because that means that we are going to develop and implement a data privacy program that will help the organization to develop softwares compliant with the regulation, or even to adapt previous products to those regulations. So let's use here the NIST privacy framework as an example. As I said before, at the beginning of this event, many US companies believe that this is just a legal matter, so they just want to work on the implementation of data protection policies. But the implementation of data protection policies, the implementation of those documents is something that should be at the end of the project. It should be the deliverable. There are many other steps that we need to follow before we get to that kind of documentation. So the first thing that we need to do, we need to conduct some sort of assessment. We need to identify and have a better understanding of the data privacy spectrum. We need to understand and identify what kind of data does the software collect? Why do we need to collect that data? Where do we store the data? Is there any sort of international data transfer? So there are so many questions that need to be answered before we even understand the things that we should change in order to solve problems that we don't even know what they are. So first, assessment. At the end of the assessment, there will be a gap analysis. We are going to point all the data privacy gaps. That means that once we point the gap, we're going to advise you that what change should you make in order to solve that gap. And what I mean by change, there are 4 different groups of things that we should work with in order to solve any kind of data privacy gap. One is procedure. We need to change procedures. So let's say that the software handles personal information in a way that we need to change in order to get compliant with the regulation. So at the end of the day, we can still do the same thing, but we got to do it differently. So procedure. The second one is documentation. Sometimes we need to work on disclaimers, privacy notices, or privacy policies, or DPAs, data privacy agreements. We need to check the kind of agreements we have with our vendors. So documentation could be the solution of a data privacy gap. The other one is training, mindset. Sometimes we need to train our team in order to make sure that every professional is able to identify a data privacy issue and be able to address that matter. Or it could be software. We got to implement some software, some privacy enhancement technology to help us with one specific data privacy matter. Once we make all the changes, we need to keep that updated. We need to keep that running. So that means that we are going to have new procedures that need to be followed from now on in order to keep the company and keep the product compliant with the regulation. So that's a different stage of this whole program. Once we have this program in place, we need to point some roles. So we need to know who the data privacy officer is going to be, who is going to be responsible for this and that, who is going to be responsible for a different matter. So we need to understand, how the organization will deal with data privacy from now on, and then we're going to work on the privacy policies, because at the end of the day, as we saw, it's some sort of legal compromise that the company is making with the consumers, with the governments. So, as I said, we need to make sure that we go through every step of that NIST privacy framework, or the ISO framework, in order to develop and implement a data privacy program. So this is something that could be considered a project, and the definition of a project is something that, it has a beginning and it ends. And why does it end? Because once you implement the program, the project itself is finished. But now those things, they become procedures that need to be followed every day. Another thing that we need to deal with, as we said before, is the international data transfer. So we need to get the self-certification. We need to work on the standard contractual clause. We need to make some changes in your contract to make sure that your European, your Indian, your Brazilian, your Argentinian, your Australian client will feel secure that your software deals with the international data transfer properly. Another thing in this whole data privacy program that we need to implement are procedures to apply privacy by design. Privacy by design is a sort of methodology that helps the team to apply privacy from scratch at the beginning of the project. So that's also something that we can help you with. So, what are the trends and the future of global privacy regulation? Nowadays, we've seen a very strong collaboration and cooperation between data protection authorities. So it has, increasing collaboration across borders. And international companies doing business internationally, will have to deal with different data protection authorities. And we've seen, with stronger enforcement mechanisms. So at the end of the day, if you didn't feel the effect of those data privacy regulations yet, at certain point you will feel and be impacted by those regulations. Of course, the first thing that you will probably feel is the possibility of losing market share, because the first question that you are going to hear about data privacy will come from your potential client. So at the end of the day, we don't want to, leave some money on the table, and we want to make sure that our software can bring some sort of security, and this feeling that our clients won't have to worry about how our software handle personal information. So there is also, artificial intelligence regulation. Many softwares are already using artificial intelligence, or many software companies, they are willing to start using artificial intelligence because it's the hype, it's the trend. But keep in mind that in many countries, the development and the use of artificial intelligence has already been regulated. Europe already has its own European AI Act. So not only you will have to comply with the data privacy regulation, but also with the artificial intelligence regulation. So that's another thing that we've been working with, and probably we're going to work more and more on that matter. Because if you want to sell to those places, you got to also make sure that your artificial intelligence model is also compliant with the local regulations. And at the end of the day, there is an international desire from different data privacy authorities to harmonize the way that data privacy is regulated. So that would be good because it would standardize and would solve one of the biggest problems, which is the fact that international software companies need to deal with local regulations, but that will take time. And I don't know if we would be able to achieve some sort of a standard because the way we see governments dealing with specific data privacy topics, on those topics, the way they deal with it are totally different. What makes things much more difficult. So that's pretty much it for today. That's what we had for everyone. That's pretty much what we wanted to bring to you in the first part of our event. So thank you so much for everyone that has been with us throughout this presentation. Feel free to reach out to us if you have, if you need any sort of assistance. We got some messages from some software companies previously asking if we would address some of the things that we have addressed here. So we believe that US software companies now understand how important it is to deal with local regulations, mostly because we want to keep selling to those places and we don't want to lose market share. And I believe that most of the companies are starting to understand that data privacy goes way beyond drafting documents, because we need data privacy management that comes before the documentation. So that's pretty much it for today. Thanks, everyone. And I hope to see you next week when we'll be talking about artificial intelligence governance. Take care.